This is Democracy Watch. Mark, what did the Supreme Court just do with regard to South Carolina's congressional map? This is a case that we have been waiting on for a long time.
Yeah, a really terrible ruling out of the Supreme Court. Supreme Court ruled 6-3, you can imagine the 6 and you can imagine the 3, that the black voters who brought this case in South Carolina saying that they were the victims of racial gerrymandering, and which a 3-judge panel agreed that they were the victims of racial gerrymandering, the U.S. Supreme Court reversed it. And the way in which they reversed it is really does not reflect well on the Supreme Court. The majority opinion in this case set back the law of racial gerrymandering, but it also reflected in a very activist court, a court that was not respectful, I thought, of the hard work that the 3-judge trial court had done.
What does this ruling mean for the future of racial gerrymandering in this country?
Yeah, so look, we've covered a lot of this on Democracy Docket, so I encourage people to read about that, but we are probably entering into an era where racial gerrymandering claims are not just going to be harder to bring, but are going to be very rare. And by the way, we're through this period once before. There was a lot of racial gerrymandering claims in the 90s, mostly, interestingly, brought by plaintiffs on the right. The original racial gerrymandering claims were claims that were advanced by very conservative legal theorists. Then we saw a cutting back on those claims, and we didn't see many. Then actually I was responsible for sort of re-upping and reinvigorating the racial gerrymandering doctrine as a progressive legal theory. In 4 cases, I brought in one in the Supreme Court from in 2015 to 2018. And the conservatives have now done a 180, and they are now, clearly want to shut the door on the increased use of that as a tool where you have so many other tools that have been taken away, Section 5 of the Voting Rights Act, for example. So it's really quite a depressing state of affairs.
Well, Justice Thomas said that he thinks that racial gerrymandering shouldn't be an issue for the courts at all. So talk about what would happen if the court basically would have agreed with him.
Yeah, I honestly, that is the thing that I was flabbergasted when I read. I am still scratching my head as how that can be possible. Because here's the thing. Justice Thomas used to be the most reliable vote to find a violation of racial gerrymandering. Why? Because Justice Thomas's jurisprudence has historically been, you should not be using race for anything. Shouldn't be using it for admissions to college, shouldn't be using it for jobs, shouldn't be using race for anything. The use of race is pernicious and shouldn't be using it. And therefore, when a legislature uses race to draw districts, that is automatically out of bounds. And that always represented, honestly, the right-wing fringe position of it. And now he has flipped entirely the other way and says the courts shouldn't be resolving racial gerrymandering cases at all. Well, if you wound up in that world, then legislatures could say, we are going to draw a map, but we don't want any black people in Congress. Or, we're going to draw a map and we want as many black people in Congress. And that used to be the exact thing that Justice Thomas said you couldn't do, like he was most suspicious of. But now he says the courts are powerless to do anything about it. If that was a green light, I can tell you what's going to happen. You're going to have explicit racial maps in parts of this country. You're going to have legislatures just saying we shouldn't have black members of Congress.
Yeah. Well, Justice Kagan, she was joined by the 2 other liberals, said that this decision effectively shuts the door to challenging racial gerrymanders and that the majority opinion is essentially telling states that they can straight up suppress the electoral influence of minority voters. So I think to your exact point, that it would seem like moving forward that would be what happens in this country.
Yeah, I think what is so disappointing about the majority opinion, now set aside Justice Thomas's opinion, which is only the opinion of one justice, but what's disappointing about the majority opinion, which is the majority, is that they engaged in a re-evaluation, which is probably the most polite way to put it, of the trial evidence. The way our system works in this country is that trial courts, trial judges like we saw in New York with the trial of Donald Trump, those judges are watching the evidence real time. They're watching the witnesses, they're listening to the questions, they're calling balls and strikes and objections, they are evaluating credibility of witnesses, and they ultimately come to a conclusion as to what the facts were. And the Supreme Court, which doesn't have the benefit of any of that, right? The Supreme Court doesn't see the witnesses live, can't ask their own questions, isn't calling balls and strikes. They're supposed to take the facts as they are given to them and just review the law. And their review of the facts is subject to what's called the clear error rule, which is that they are only to upset the finding of fact if the trial judge's decision on the facts was so clearly erroneous that no one reasonable could have found the facts that way. And when you read Justice Alito's opinion, he just does a wholesale reevaluation of the facts. Like he says he doesn't believe this expert, he believes that expert, and it's just honestly not the role of an appellate court in the Supreme Court. And that is very, very dangerous because, as Justice Kagan said, that really does mean that the bar here for trial judges to call balls and strikes in racial gerrymandering claims, is going to meet a very hostile Supreme Court.
Yeah, I mean, it basically just means that anything lower courts do that don't ultimately comport with the political ideology of the Supreme Court is up to be overturned, because you don't have to follow the clear error rule. It's just basically the Supreme Court doesn't like what happened at a lower court, and so it just takes the ball into their own court and relitigates the entire case to their liking.
Right. The other thing that that Justice Alito's opinion does, I think, is just is turning the Constitution on its head. He basically says, one of the reasons why it's now very difficult to prove a racial gerrymandering claim is he says that legislatures deserve a presumption of good faith. Now, let me ask you this. The theory of racial gerrymandering is under the 14th and 15th Amendments of the Constitution, which were explicitly limits on the states because we didn't believe after the Civil War that they deserved the presumption of good faith when it came to race matters, right? We have these amendments because, in fact, we don't trust these states to be fair to black people. That's why they were passed. And he basically says, no, they deserve a presumption of good faith under these amendments. Now, isn't it interesting, Brian? There was another 14th Amendment case that the court heard this term, where somehow the state of Colorado didn't get the presumption of good faith. Any recollection of what that case may have been about?
Something. It's starting to come into my mind. It's at the tip of my tongue here.
Oh, Donald Trump being eligible for the ballot.
Yeah.
Oh, in that case, the state of Colorado wasn't entitled to, sort of decide how to run things. But here, when it comes to state of South Carolina, presumption of good faith. We don't want to upset what the states think.
Right. So going back to
don't you find that interesting?
I find it. I could not be less surprised if.
You're not surprised. I was surprised.
I think less surprising than that would be the sun rising in the morning, basically. Is this issue of South Carolina's maps dead forever, or can it be relitigated after this election cycle then? Like, what does this, this was the Supreme Court. They're the final arbiter of these issues. So does that mean that after they've handed their decision down, South Carolina can't bring forward another lawsuit to rectify a racially gerrymandered map?
Yeah, this is it for South Carolina. The South Carolina map is not going to be challenged any further on racial gerrymandering grounds. The question is, what does it do for the other racial gerrymandering claims out there in the system, of which there are many? And does it mean the end to all of those? And by the way, let's not forget, in the state of Louisiana, it is white voters who have brought a racial gerrymandering claim to try to strike down the map that my team won, having brought a Voting Rights Act claim, right? Remember, we won a case, got 2 congressional districts for black voters as a result of that victory, and a bunch of white voters brought a racial gerrymandering claim and prevailed at the trial court. Now, that was stayed by the Supreme Court because it was too close to the election, but it'll be curious to see whether that case also dies on this vine or whether there was somehow an exception for the white voter case.
Well, correct me if I'm wrong, but the Supreme Court had seemed to be surprisingly receptive to protecting Section 2 of the Voting Rights Act claims. Why was this case suddenly different? Why the change of heart here?
Like I said, this is a very weird reversal because for decades, the law of districting was that the liberal justices were very pro-Voting Rights Act. And the conservative justices were cool to it, not hostile to it, but cool to it, but very in favor of racial gerrymandering claims because their basic position was we should be using race less to draw districts. And what's interesting is you're exactly right. The Supreme Court surprised a lot of people by upholding the decision in the Alabama case, which was a Section 2 case. But when it came to the South Carolina case, all of a sudden the conservatives turned against the racial gerrymandering theory. And the only thing I can say is that, as I mentioned, I was among the lawyers who sort of invigorated and sort of put a new gloss on the racial gerrymandering claims in the 2015 to 2018 time period. And it's almost like I look back, like maybe the conservatives were caught off guard that they were voting for something that was then electing more black elected members of Congress, or more Democrats. And so now they have like regrouped to cut back on it. But it's not easy for me to explain to someone why they ruled the way they did in the Harvard admissions case, which was very hostile to the use of race. And yet in this case, seemed to be fine that black voters were being shuffled out of Nancy Mace's district because they were black voters.
Yeah, well, I think for most of us out here, we can recognize the reason why, and it's because one aligns with their political ideology, and the other doesn't redound to their political benefit, with regard to the maps. And so I think it's just as simple as that. I think we're seeing the reality of who these justices are, the conservative justices, kind of get exposed, and that is that they are little more than just Jim Jordan and Marjorie Taylor Greene in robes.
Yeah, I mean, look, I think that it's very frustrating as a lawyer. It's very frustrating as someone who advocates for the rule of law and frankly regularly advocates people that they should put their trust in the judicial system. That when the political branches fail them, which all too often now they do in Republican-controlled states, that we can at least count on the courts to protect fundamental rights. So we can count on the courts to make sure we have free and fair elections. We can count on the courts to preserve democracy. And it is frustrating that against that backdrop, a court that lost so much legitimacy over the Dobbs decision, and I'm not speaking now, I mean, obviously I think they were wrong, but like just objectively, as an observer, they lost a lot of legitimacy by overturning a 60-year-old precedent simply based on the composition change of the court. And you would have thought that at that moment, it was a wake-up call for them to say, let's take a step back. You know what, let's take a step back. Let's be more in line with where the country is, where the mainstream legal establishment is, how the Constitution has been interpreted. And this doesn't reflect that. This reflects a court that thinks that, you know what, they can push forward in rulings that do look on their face to have a partisan take, that they can delay rulings that involve the president's immunity claim, where it might benefit him politically. They can expedite rulings in claims like the one in Colorado, where it might benefit him politically. And I think it's very, very sad for the institution of the court.
Well, look, I think all of this underscores the fact that the courts have become ground zero in this fight for democracy. And, for those watching right now, to support the invaluable work that Mark and his team do, in fighting those fights in court, please sign up for Democracy Docket. It's the free news outlet he founded to focus on everything voting elections. I'll put the link on this screen and also in the post description of this video. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.